Hello everyone and welcome to Lovant. Right now while making this second video, I'm seeing my very first 22 subscribers to this channel. Thank you to all of you for showing the support. Through Lovant channel, I create and post law related educational videos for you. So I hope you too become the part of this growing community by subscribing and watching Lovant videos and sharing the knowledge. Now let's probe into the question of what the different parts of a contract are, or in other words, what is the basic structure of drafting a contract. If you have read or tried to interpret or draft contracts, you must have by now understood that it is a challenge to identify a uniform basic structure between all of them. This is the main reason why you should not rely on a specific template. And the templates which you see on the internet may belong to the laws of different countries which may not apply to your or your client's jurisdiction. Moreover, the specifications of the transactions to which you are drafting the contract may be different than those in that template. So, beware of those ready-made templates and try to stay away from that cut, copy, paste culture. Try to make your work original and relatable to the situation. And to make it possible, it is essential for you to know the basic structure on which you can build your contract. This basic structure of contract can be divided into four main groups. The first group is introductory clauses. The second group is operative clauses. The third group is boilerplate clauses. And under the fourth group, you get annexures or schedules. Let's begin with our first clause, that is introductory clause. Introductory clauses are all about facts and interpretations. To be specific, these include the title of the contract, date, name of the parties, recitals, definitions, and interpretation clauses. In title, you must mention the nature of the contract, like say non-disclosure agreement. Then you need to mention the date of execution and effective date. Now, what is the difference between date of execution and effective date? Well, date of execution is usually the date on which the agreement will be executed or signed. On the other hand, effective date means the date from which the terms and conditions in the agreement actually become applicable. Note it out that in some occasions, the date of execution and effective date will be same, and in some other occasions, these two dates may be different. Be cautious about these matters because you don't get this information from the templates. Yes. Well, next comes the names of the parties. They are used numerous times throughout the contract papers. So, for the convenience, these names can be shortened. For example, if one of the parties is ABCD Private Limited, it can be mentioned as the company or the receiving party in the subsequent lines. But this point must be clarified in the beginning itself, like the way it is shown in this example. Now, this recital section is interesting. You must have seen the section where it is mentioned whereas and some short sentences with semicolon follow. They are called as recitals. Recitals give the background story or background information of the parties. So, by reading recitals, you come to know about how the parties came together to carry out whatever the transactions they are going to enter through this contract or agreement. Next, in the definitions clause, as the name states, you get to define the meaning of the words which seem confusing or complicated. By reading the definitions of those words, it will be easier to get clarity on what the parties actually mean whenever those words appear in that particular contract. Well, that makes matters easier to understand. Don't you agree? Next comes the interpretation clause. Did you ever come across the sentence saying, "The captions of this agreement are merely for reference and do not limit or describe the scope of this agreement"? Well, that's an example for interpretation clause. In this clause, you get an idea about the basic rules which would apply while interpreting or understanding a contract. Now let's come to the second group, which is operative clause. It is under operative clauses that you get full picture about the business or commercial intentions of the parties. It is here that you come to know about the actual transaction which is going to happen, or in other words, what is being given and what is being taken by the parties. For example, a seller will have an intention to generate profit on selling a product, and the buyer will have an intention to get value or satisfaction out of that product higher than what he is agreeing to pay. Here, the seller is giving his product and taking money, and the buyer is giving the money and taking the product. So it is all about what is being given and what is being taken. So that was the gist about operative clause. Under operative clause, you find several heads of clauses such as conditions, warranties, payment clauses, termination clause, consequence of breach, covenants, and exclusivity clause. Note that these names won't be the same in all the contracts. The names may differ from one contract to another depending upon the nature of situations and transactions. Overall, operative clauses state about the obligations of the parties and also about how they are supposed to fulfill their obligations. Next, let's come to the third main division in the contract drafting, which is the boilerplate clause. The boilerplate clauses are used to deal with happening or non-happening of certain events, in the sense contingent events. So, while framing the boilerplate clauses, you must think about future events which may or may not occur and what will be the measures which the parties can adopt based on them. The best example for a boilerplate clause is force majeure clause. This clause is quite trending now due to the COVID-19 lockdown effects. Lately, several articles have been and are being published based on force majeure clause. It has gained such a momentum. If you're wondering what force majeure is, well, force majeure clause will provide the alternative measures for consequences if parties cannot fulfill their obligations for reasons beyond their control. So, some of the boilerplate clauses are confidentiality clause, force majeure clause, which I mentioned earlier, waiver clause, limitation of liability, intellectual property related clauses like copyright, patents and all, then notices, indemnity, governing law and dispute resolution. Now let's see the last part of the contract drafting, which is annexures and schedules. Annexures are not considered as part of the main document of the contract. These are separate documents. Parties to the agreement may change the information in the annexure without affecting the validity of the agreement. An example to an annexure is the sanction letter. It is a separate document and not part of the main agreement papers. In schedules, we generally find the long technical information related to the contracts. Schedules are used as quick references to avoid repeating such long technical information every time in the contract. For example, under schedules, you can give the full details of the security provided in case of a lending agreement. Further, if you want to clarify that a schedule is a part of the body of contract, then you can state it by using sentences such as the exhibits and schedules hereto are an integral part of this agreement and are deemed incorporated by reference herein, or any such other sentences which you deem fit. After going through all these four important groups, the parties must undertake a final step, which is execution of the contract, which means signing of the contract at the end by the parties. Their signatures ensure that they have consented to everything which is mentioned in that contract. Therefore, Before concluding the drafting of a contract, ensure that you have covered all the critical clauses. Don't use any template blindly, as it may lead to copy-pasting irrelevant clauses to the one which you are preparing. Such editing mistake would make you look unprofessional too. So be thoughtful before framing each and every clause. And don't feel frustrated about the drafting skills. Just keep framing as many contract drafts as you can. This will give you a practical sense of understanding as you move along. I hope this video has helped you to some extent. If so, then please like this video, subscribe to Lovand and share this video with your friends. This will motivate me to bring out more important and interesting contents. Let me know about your thoughts on contract drafting in the comment section, and we shall meet in the next video. Bye.